Our former president, Jacob Zuma, may very well go back to jail. This after the Constitutional Court dismissed a bid by the Department of Correctional Services to overturn a previous Supreme Court of Appeal ruling. Now remember, Zuma was given a 15-month jail sentence by the Constitutional Court. It was for contempt after he refused to testify at the Zondo Commission. So let's find out legally, what does this look like? Expert Mpumelelo Zikalala joining us this morning. Mpumelelo, good to have you back on eNCA. I appreciate your time. So is this now a done deal? Does the former president have to go back to jail?
I would say on paper and yes, in terms of the law, yes, it is a done deal. However, practically, there are still ways in which we can see the former president not actually going back to jail. Let's look at what the ConCourt was saying yesterday. It was saying when it comes to the legal compliance or correctness or compliance with the law, or technically speaking, the decision which was taken, if you need to reverse it, then you must take the detainee back, in this case, the former president, back to the Correctional Services Center. And then it's within Correctional Services Center in which the commissioner will take a decision on how to deal with the matter, regardless of how they were considered at the time when it has been suspended or not. Now, the commissioner, when he does that, he looks at the Correctional Services Act, and I could only see a few clauses in which he can be able to do that. First one is Section 44, which deals with temporary leave, which you can say, I'm granting you temporary leave for the rest of the months in which you've been serving outside, and those that have been regarded by the court as being technically invalid, so that you're able to reintegrate back into the community. Or I'm going to use those particular months to then say, either your sentence has already been finished and ended with us, or let's consider you for parole, and before those particular communities actually sit, let's give you time to be at home and not actually physically in prison. So the court was quite correct in terms of saying, on a technical basis, we're not going to compromise. We're a court of determining whether something is good and something has been done correctly. In this day, it was done incorrectly, but we're not going to be a court of legal advisors advising the Correctional Services Department and how to handle it matters. The Correctional Services Act would be able to do that.
So it doesn't actually come down to the correctional court. That is just taking a look at the legal framework if it ticks all the right boxes as well. I'm going to circle back to the Apex Court in a moment in Mpumelelo. So essentially this rests with the Commissioner of Correctional Services. That's what this comes down to. That's the person who decides yes or no based on various conditions at this stage.
Definitely. And before you decide whether yes or no, you're supposed to do that. You ought to do that in compliance with the Act. Let's remember that we are in the situation that we're in now because the then commissioner did not follow what the Correctional Services Act was actually saying. So if you want to be correct this time, you have to take a step back and then say, let me look and consider the situation and the facts that have taken place. What is it? How many months are left for this particular detainee in order to finish their sentence? Can I offer them temporary leave, for example, and say for purposes related to the integration of the sentence offender into the community or any other reason that might be there? It is a prerogative given to me as a commissioner, and that's exactly what I'm going to do. However, if I feel that the reason is not enough, let me use this time for that integration part while preparing the part of parole or while allowing the sentence of the prisoner to be done and dusted, including the other months in which the court, by determining that the former president must go back to prison, or simply say, we're not going to consider that the amount of time that you spent outside is actually a time in which you're regarded as a detainee. Another question, though, that I think the court ought to have answered is this one. You must look at the interest of all the litigants that are in front of you. That's what I believe. And when you do that, you ought then to say, let me look at you as an individual former president. There are certain rights which are accrued to you. There are certain things that have taken place. By the delivery of this order, am I technically or indirectly increasing the number of months in which you are going to be regarded as a detainee? If the answer is yes, let's check. Were you released in prison based on your own will, or was it a circumstance in which you were simply given instructions and you followed them? Now, if you're a beneficiary of any poison fruits, yes, you're supposed to take whatever that you've received back, but it can't be that you're going to be punished extra, because if we stick to what the court has stated to us, regardless of looking at what the Correctional Services Act actually says, it basically means that there are a few extra months that have been added into the sentence of the former president without those particular extra months being provided to by the law or any judicial officer that is. Now, on a technical basis and on a fairness basis, I don't think that is something that even our constitutional court ought to have allowed to happen. And the best way of doing so would have said, let's look at the circumstances here. We are dealing with unique circumstances and you need to protect the interests and the rights of individuals. Let's do so. Now, that wouldn't have been something that the court would have been unfamiliar with. Take a step back and look and remember when there was an issue with our SASSA payments and a certain company that was there being awarded a contract which was illegal. The court did state, in fact, it was the ConCourt stating that even though the contract is illegal, it's not supposed to be there, but we are simply doing it for the interest of the number of the millions of SASSA beneficiaries that are there. And we are saying to the department, continue with the illegal contract up until you are able to sort yourself out, even though the contract is illegal. So I think that extra step back by the court ought to have taken in this place in terms of saying, regardless of who the litigant is, let us protect your let us protect your rights. And part of it will be to make sure that even though technically speaking you're supposed to go back to prison, however, let's consider the time that was spent outside as being detained.
Okay, I see. It's all about timelines and what was perceived to have been time served and how was that time served. Okay, so it's actually a lot more complicated than we realized as well. But as always, I appreciate your time. Experts making sense of this for me and you, Mpumelelo Zikalala.